For judgment, item number 1.
The petition is allowed. It is directed that the petitioner's husband shall be treated as if he had died in harness on 14/5/19, and accordingly all consequential benefits and family pension be released to the petitioner. No back wages shall, however, be admissible. The entire exercise to be completed within 5 months.
For judgment, item number 2.
As a result, the writ petition is allowed and the impugned findings of the PNR department dated 15/6/24 and 4/2/25 are quashed and set aside. State respondents shall compute the length of service for pension in respect of the petitioner from 15/1/93 as provided in the OM dated 31/8/2017.
May please, Lordship. My Lord, allow me to mention hearing item number 15.
1/5.
Yes, my Lord. My Lord, here we were supposed to file affidavit in reply to the affidavit filed by the R2, respondent number 2. However, because of some difficulties faced by the leading counsel, we could not file. So allow us some time to file the affidavit in reply. And if this matter can be fixed on 17th of November for final hearing and disposal.
You are for?
I am for the petitioner.
Petitioner. Learned Counsel Mr. Taka Kichu, appearing for the petitioner, prays for some time in order to file the affidavit in reply.
My Lord.
As he had, what happened? Leading counsel?
As the leading counsel had faced some difficulties.
As the leading counsel has some difficulties. So accordingly, time is allowed. List the matter on 17th.
May I please, Your Lordship?
Yes, 17th.
November 4.
If the petitioner could be given a last chance since they have taken enough time.
My Lord, yes.
Okay, we'll list it for hearing. We'll list it for
On 17th November.
Yes, on 17th. List it for hearing on 17th because its pleadings are complete
My
except
Lord.
for your
Yes, my Lord.
replies on 17th November, and the petitioner shall file the affidavit in reply before the next date and supply copy to the respondents. Yes.
Much obliged. Oh, my lord, there is an interim.
The interim order passed earlier shall continue till the next date.
Much obliged.
Yes.
May I please, Your Lordship? My Lord, I beg to mention item number 16 on behalf of S. Mary, my Lord. Kindly list the matter after 2 weeks, my Lord.
Petitioner? Yes. No objection. Learned counsel for the petitioner, Mr. Such and such present. Learned PP Nagaland, Mr. Tiba Pom submits that MSS Mary PP is appearing this matter and has some difficulties today, and accordingly list the matter for after
2 weeks, my Lord.
After
Yes.
2 weeks. Yes.
Much obliged.
May I please, Lordship? Lordship, I beg to mention item 17. I am for the petitioner here, Lordship. Lordship, I have personal difficulties today. So, matter may be taken up after vacation, Lordship.
After vacation. Learned counsel for the petitioner, Mr. Wati Jamir is present. He has prayed for listing the matter after the vacation as he has some difficulties today. Prayer is allowed. Learned counsel for the respondents have no objection. List after the puja vacations. Yes.
Lordship, there is an interim. That may be
Interim.
extended.
The interim order passed earlier shall continue till the next date.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item 5. I pray this matter be listed after 3 weeks, Lordship.
You are for the appellant.
Appellant, Lordship.
Learned counsel for the appellant, Mr. Such praise for listing the matter after 3 weeks. So learned government, learned PP, Mr. V. Jimomi is present, and amicus is for respondent, private respondent.
Appellant, Lordship.
No, there is one amicus also.
Amicus
And
for the complainant respondent.
Okay. Anyway, list the matter after 3 weeks. You said 3 weeks, no?
3 weeks.
As prayed by the appellate. Yes.
Much obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 18, hearing item number 18. Your Lordship, I humbly pray that it may be listed after the puja break.
Okay. You are for the petitioner?
Yes, my Lord.
General counsel for the petitioner, Miss
Ms. Kikrisina.
Kikrisina, who has prayed for listing the matter after the puja vacations. Stop learning government advocate is present. List after the puja vacation. Yes.
Obligement.
May I please, my Lord?
Yes.
Lordship, I beg to mention item number 6.
Item 6.
6, Your Lordship. Lordship, on the last occasion, I was asked to receive the instruction with regards to the name of the arbitrator.
Yes.
Your Lordship, there appears to be some communications gap between the department and the government. Your Lordship, I have, in fact, had a meeting with them. Now, Your Lordship, the proposed name that the petitioner have taken in this arbitration petition, Your Lordship, they are seeking a 2 weeks time so that they will come to a conclusion whether they will accept this name or from the list of arbitrators that this High Court have.
No,
Your
who
Lordship.
have they suggested?
The government, BK,
No.
Justice Retired BK Sharma, Your Lordship.
But his name is not,
Not in the list.
Not in the list.
Correct, Your Lordship.
So you'll have to choose someone from the list.
Yes. So from the list of
Otherwise, they are ready for arbitration.
yes, Your Lordship.
Has
So
to be, because
yes,
the
so
clause is already there.
yes. So on the concurrence of the government, if they are ready for the arbitration, then from the list of arbitrators that we have, they wanted to propose a name to that. So if 2 weeks time may kindly be granted so that we can.
Okay, let it be a last chance because it's been dragging on for a long
Lordship.
Learned counsel for the petitioner, Ms. Mika is present. Learned senior government advocate, Mr. N. Angami has submitted that the government is in the process of deciding upon the arbitrator in the present case and would need 2 weeks' time to receive further instructions. Stop list after 2 weeks. Yes.
Much
Deeply
obliged.
obliged, my Lord.
May I please, Your Lordship? Lordship, may I beg to mention item 19 and 20. I'm appearing on behalf of leading counsel DJ Haloi. The counsel is in bereavement, so currently list the matter of the DJ Haloi. Yes.
Please give the spelling.
Okay.
Learned counsel for the petitioner submits that the leading counsel, Mr. Such and such, is in bereavement and accordingly prays for listing the matter when
27 October.
on 27th October. So, prayer is allowed, list on 27 October. Learned PP is present. Yes.
Obliged.
Please, Your Lordship.
Yes.
Lordship, I beg to mention items 11 and 14. Lordship, here I'm appearing for respondent number 1, on behalf of B.N. Sharma. Lordship, if the matter can come after the puja vacation, taking
In
the
both
consent.
items, R1.
R1.
Third learned counsel for respondent number 1 in both the case, same order. The learned counsel has prayed for listing the matter after the puja vacations. So learned counsel for the appellant.
11:40.
Who's for the appellant? You are there for the
My
appellant?
lord, yes,
But in both,
yes, my lord.
learned counsel for the appellant, Mr. Chakakichu has no objection. List after the puja vacations. Yes.
Obliged, my lord.
My Lord, I also would like to mention items 7 and 8 on the admissions list. Lordship, in the last occasion, the respondent, and for the respondents were directed to file the objection. However, we have served the copy to the to the appellants, but we are yet to file it for this honorable court, the objection. So if the,
Objection in
the IA.
petition.
for condemnation, Lordship.
Condemnation,
If the matter can come up after the puja vacation as well.
Heard learned counsel for the respondent. It is submitted that the objection to the IA is yet to be filed in the registry. So accordingly, he has prayed for listing the matter after the puja break. List after the puja vacation.
Also obliged, Lordship.
Lordship, kindly pardon me, but there is an interim order in item number 19 and 20, so it may be continued.
19 and 20, the interim order passed earlier shall continue till the next date. Yes.
For motion, item number 3.
Condemnation, I think.
Yes, Your Lordship. There has been
Yes, yes, Kim Penna for the applicant. The present application has been filed under Section 5 of the Indian Limitation Act, praying for condemnation of delay of 430 days in filing the connected MSC appeal. Stop. Wait. Connected MSC appeal arising out of, where is judgment and order?
19/7/2024.
No, the page. Judgment and order
14 to 31.
dated 19/7/2024 in MSC case number 112 of 2016, passed by the Member Motor Accident Claims Tribunal, Dimapur, Nagaland. Stop. Para. Issue notice to the respondents number 1, 2, 3, and 4. Returnable within 1 month, returnable within 4 weeks. Stop. The counsel for the petitioner, the counsel for the applicant, appellant shall take steps for service on the respondents by registered post as well as usual process within 3 working days from today. For list after 4 weeks. Yes.
Obliged, Your Lordship.
For motion from the supplementary course list, item number 21.
May it please your Lordship. Your Lordship, if the matter can be taken up after some time, Your Lordship. The council is on its legs in court 1.
We have to issue notice only. They have to get the case ready.
Lordship.
This bail application under section 483 of the BNSS has been filed, praying for release of the accused Kevilizo Ruprio on bail, who has been arrested on 29/8/2025 in connection with special case number 22/2025 in narcotic PS case number 11/2025 under section 22 clause B and 29 of the NTPS Act 1985. So, issue notice No. As learned PP, Mr. Tipapom has accepted notice, no formal notice is called for. Stop. Accordingly, list, when can you produce?
After 2 weeks, my lord.
After 2 weeks, so today is 25th. 8 is Wednesday. 7th.
7, okay, my lord.
List on 7th October 2025. Stop. The learned PP shall produce the updated case diary on the next date.
Much obliged.
For motion, item number 22.
Yes, my lord.
Which order violation?
Your Lordship, here, Annexure 1, page 13. The operative portion is at para 9.
Page 13.
Yes, Your Lordship. Page 13, para 9.
In light of your scale pay.
Yes, Your Lordship.
So the time given was 3 months. 3 months, and this was dated 12/3. The present petition under section 11 and 12 of the Contempt of Courts Act 1971 read with the Contempt of Courts Gauhati High Court under bracket rules 1977 and Article 215 of the Constitution of India has been filed by the petitioner alleging willful disobedience of this court's order dated 12/3/2025 passed in WPC 227/2022. Stop. Learned counsel for the petitioner, Ms. Such and Such. Stop. Issue notice on the respondents number 1, 2, 3, 4, 5, 6, and 7 to show cause as to why contempt proceedings should not be initiated against them. Stop. The returnable within 4 weeks. Stop. Para. Learned counsel for the petitioner shall take steps for service on the respondents by registered post as well as usual process within 3 working days. List after 4 weeks.
Acknowledged, my lord.
For motion, item number 23.
May it please your lordship, man.
Yes.
I'm sorry again to trouble the court.
What
Because
is-
kindly see why again they have come up with the same application which your lordship has already interfered. And lordship said that there is a 3 of 2025, there is an order passed and that you can't proceed, interim order is passed. Again they have done it, same thing. Kindly see their application.
Another application again. Same
Another application. Same application. This is an abuse of the process of the court and there is a judgment of the Supreme.
Has the court passed any order on that application?
Yes, court has passed. That's the only problem. Court has said, your lordship, that there was no occasion. The court, because the court also may not be aware of those situations. I don't know. They have suppressed all the material facts. Kindly see. First, my lord will kindly see. First, your lordship will kindly see your judgment. Then it will be clear. Your lordship judgment at page 185. Kindly see 185.
Okay, I remember.
Your lordship, then your lordship, then forget. My lordship, remember that. Kindly say their application is, your lordship will find their application starts from page 49. 49. 49. 557 of 2025. Your lordship got it. Now
Yes.
see the prayer at page 72. See 72. 72.
Yes.
In view prayer, in view of so and so B, permit the Directorate of Enforcement to effect the arrest of the accused under section 19 of PMLA upon his production before the Honorable Court. This is his prayer. And kindly see page 48. Kindly see page 48. Same. See page 48.
48.
Page 48 is the order. 48 is the order.
Lordship,
48 is the order.
I'm appearing on behalf of respondent PP Kiduzi. Lordship, we have just received the copy, so 2 weeks time may be granted to us.
Yes, yes, that will be given. But we just want to see whether any interim order is called for. Yes.
Yes. 48, my lord.
Yes.
Receive application so and so, copy the petition, sir. Fixing so and so, reply of the application on 16/10/2006, 10/2025. Now the Supreme Court in one of the judgments says that it is barred. There is a legal bar. It is abuse of the process of the court. Now, Lordship judgment kindly see now. See the judgment. See the order. So clear, so clear. Suppose someone is agree, you can go. No one is stopping anyone. So clear the judgment. Kindly see at page 185. Kindly see 185. See 185. Entire proceeding we have challenged. See page 44 at 185. 3 paragraphs I read of the judgment. Page 185. 185.
Yes.
See paragraph 44. In the present case, such an application praying for production of the petitioner for the purpose of custodial interrogation was filed by the respondent being IA 465 of 2024. However, the production warrant was issued by the impugn order dated 4/8/2025 without hearing. Interesting in IA, so and so at para 26, respondent stated interim relief granted by this court in criminal revision 3 of 2025 stands on fragile ground as it was based on incomplete and misleading representation by the petitioner. This court is of the view that there can be no fragile or strong interim protection. This court in order dated 21/3/2025 in criminal revision 3 of 2025 in no uncertain terms stated operation of the impugn order dated 13/12/2024 shall remain stayed and a non-bailable warrant of arrest issued in pursuance to the impugn order shall also remain stayed till the next day. This interim protection has been extended from time to time and still in operation. Now, Your Lordship, explain para 45. If the purpose of the production warrant is to allow the investigating agency to take custody of the accused for interrogation in the same case where non-bailable warrant of arrest has been stayed, it would amount to circumventing the stay order granted by this court in criminal revision 3 of 2025. This would defeat the protection granted by the court. Once the NBW against the petitioner is stayed, respondent cannot indirectly secure custody of the accused in the same case by seeking a production warrant. Now, last 4 lines. Thus, when the non-bailable warrant is stayed, the trial court could not have issued, last 4 lines, have issued the production warrant on the application of the respondent, as this would effectively amount in getting the accused into custody for the purpose of investigation, as that would violate what the stay order sought to protect. Now, this is what Your Lordship has protected. It's barred by res judicata. My Lord, there is judgment that in a criminal case also, there is a judgment, it is always barred by res judicata also. So this petition is not...
Mr. Das, don't you feel that this IE 465/24 is already disposed?
Yes, correct.
That
Right.
chapter is closed.
Yes.
So they can always come with another application.
But the problem is,
Yes.
they with greatest respect, my lord, they cannot come into any application now because clear cut, the purpose behind, Your Lordship has already stated in the order. The purpose is what?
Purpose was to arrest,
Then, my lord, it is not an abuse. That means they are circumventing all the time courts. My lord, courts, my lord, there has to be a respect of the court's order, my lord. We have got all respect. If somebody is agreed by this order, one is free to go anywhere. If I am agreed, I am free. But you cannot disrespect.
At least you should wait till the
correct
petition is...
Absolutely. This is what I am on, my lord. My lord, these are courts, my lord. We have to respect courts, my lord. Then what Your Lordship remembers on the last occasion, they said we are going to Supreme Court against the order. They want adjournment. Oh, no one can stop anyone, my lord. But whenever there is an order, whoever, my lord, learned trial court's order, high court's order, we should respect the orders. No, entire proceeding has been impugned in this case, my lord. Entire proceeding. This could not have, but they could not, they should have waited. It is barred by adjudicator, they could have waited, my lord. Why they have not waited? And your lordship, very interesting. Kindly see,
No,
kindly see.
at this stage, we can only issue notice and then stay for the.
Yes, that's right. They stay the proceeding and let a notice be issued and they will give a reply, whatever they want to give a reply.
Learned counsel, learned senior counsel for the petitioner, Mr. D. Das, assisted by Mr.
Yes, yes. Yes.
Stop. The petitioner herein seeks to challenge the order dated 16/9/2025 passed by the learned special judge PMLA Dimapur, Nagaland in IA number 557 of 2025 arising out of M.L. case number, or you just give the full form, money laundering arising out of money laundering case number 1 of 2024. Taking on record the respondent's application under section 19 of the PMLA 2002, seeking permission to arrest the petitioner and directing issuance of notice to the petitioner. Stop. The petitioner further seeks to quash all the proceedings in IA number 557 of 2025 pending before the learned special judge PMLA Dimapur. Stop. The petitioner has submitted that this court in criminal petition.
Page 168. Criminal petition. 30 of 2025. Criminal petition.
Petition 30 of 2025 had directed that, had observed that an application praying for protection of the petitioner for the purpose of custodial interrogation could not have been issued when the stay order given by this court in Criminal Revision 3 of 2025 by order dated 21/3/2025 is in operation. Stop. The learned counsel further submits that the IA 557 of 2025 is nothing but a repetition of the earlier IA number 465 of 2025, wherein the respondent had sought issuance of protection warrant for the custodial interrogation of the petitioner. Stop. Para. Issue notice to the respondent, returnable within 4 weeks. The petitioner shall take steps for, you have already received copy. Okay. Councils, these steps. Learned counsel, Miss such and such, enters appearance on behalf of the sole respondent, and prays for some time to receive instruction as the special PP has some difficulties today. So accordingly list the matter after 4 weeks, and the respondent is also at liberty to file objection if so advised till the next returnable the order, impugned order dated 9/2025 passed in
69.
yes 16/9/2025 passed in IA 577 of 2025.
No, it is 550. It is 557. Wrongly, it is IA. We checked the learned trial court's record is IA 557. Actually, it is 557. Because in IA 49, it is 557. It is wrongly typed.
In the order, it says 577.
But it is actually 557. We checked the trial court's record also.
Okay,
557.
557 of 2025 and arising out of money laundering case 1 of 2024 shall remain suspended till the next returnable date. Yes.
I am deeply obliged, madam. I am deeply obliged.
For admission, item number 4.
Lordship,
Yes.
to file a affidavit, IA, to implead the Home Commissioner Nagaland. So by that order, on the basis of that order, IA 163 was filed, and it came up on 8/9/2025. But the Home Commissioner is not implemented as per the proceeding of the court. So I just pray to your Lordship that in order to avoid all those technical difficulties, so Home Commissioner now present is Abhishek Sinha, IS. His name should be properly implemented. And in the meantime, I am praying for time to file a power.
After the petition is allowed, you have to file an amended cause title, putting the name of Abhijit Sinha as respondent number.
Yeah, it came up on.
We have already done.
It came up, IA 163 came up on 8th September, but none appeared as per the record. None appears.
appeared.
Yes, it is there, it is very clear. So my submission is,
Let me see.
there should not be any lapses on the part of the proceeding record. As per that order, none appears. So if parties not appeared,
RA number
163,
163.
if we check the order dated 8 September, none of the parties appeared.
9th September, I think, 9th.
It was, as per my record, it was
No,
listed
8,
on
8, 9 is none appears for the petitioner when the
Yes.
matter is called and is passed over.
Okay.
Then 9/9/25,
Okay.
9/9/25
Appeared.
order, yes,
The
appeared.
next day.
And then Abhijit Sinha IS such and such may be allowed to be impleted as
Okay.
respondent.
So-
Already done.
And the petitioner
We
shall
have
file
served you even
amended
copies.
cause title within a period of 1 week. Done.
Okay, if it is clear, then I have to file a power.
Yes,
There's
yes,
one
done.
Home Commissioner,
So he is now
I have
impleted
instruction.
as respondent number 4.
4.
Learned counsel for the petitioner, Ms. Zimomi, stop. I heard also heard Mr. Im Song, who enters appearance for respondent number 4, the newly impleted respondent number 4. Stop. Mr. Im Song has prayed for some time to file his power as well as the affidavit in opposition. Stop. When?
3 weeks.
So please
Because
the matter.
last week, so I had a meeting with the Home Commissioner. Then I'm expecting during Puja or right after Puja, we have to
Okay,
discuss on this.
list after 3 weeks, yes, in order to enable the respondent number 4 to file his affidavit. The other respondents have filed. 1, 2, 3. Mr. N. Longkomar, please for respondent number 2.
These two are surviving.
Okay, list
But
after
Lordship,
3 weeks.
in the present Home Commissioner, since the previous Home Commissioners have already submitted before this Honorable Court, appeared before this Honorable Court, that his appointment order is to be placed before this Honorable Court. There are at least 4 or 5 times it has been stated before this Honorable Court. So is there any other option that they again have to file their affidavit in opposition?
Lordship, the problem is earlier Home Commissioner has assured 1 month. Right after he was replaced by the present one.
Of course.
So basing on that earlier submission of the Home Commissioner, where discussion is underway now. So now by
No,
implementing
see,
the new,
in contempt, since it's in their individual capacity.
Yes.
Of course,
He
of
has
course.
to file his affidavit.
The affidavit, it's power of,
Power.
that is, they have to file.
List.
But I think he's asking for again affidavit in opposition also.
no, I have to file power,
Power?
and if necessary.
If necessary,
Yes.
affidavit.
Yes.
List after 3 weeks. Yes.
For admission, item number 9, POCSO matter. Please mute the audio.
2 to 8. I've also filed an affidavit in this regard. If clauses 2 to 8 may be made a part of the court's record.
Let me see.
Page number 20, my lord.
Page 20, clause 2.
2 to 8.
That the accused person undertakes this one.
Yes, yes.
Not to establish any contact with the victim, her family and friends, directly or indirectly. You want this to be reflected?
Yes, clause 2 to 8, if is my humble prayer insofar as this.
2 to 8.
Yes, 2 to 8.
Okay. The petitioner herein is seeking to quash the FIR dated 23/8/2025 and you can see it, and connected criminal proceedings in respect of GR case number 94/2025 in connection with Women PS case number 0010/2025 on the basis of a compromise deed dated 12/9/2025 executed between the petitioner and the respondent number 2. Stop. Heard learned counsel for the petitioner, Mr. Such and such, as well as Mr. Eli Lawler for the respondent number 2, and the learned PP, Mr. Tibakom. Stop. Para. It is the case of the petitioner that an FIR dated 23/8/2025 had been lodged before the Women PS Kohima, Nagaland by the respondent number 2, stating that the petitioner had been harassing/stalking, cyberbullying and cyber-stalking the respondent number 2 for 4 months. Stop. And further, on 22/8/2025, at around 10:30 p.m., the petitioner had come to her residence and forcefully knocked on her door. And only after she informed the police, the petitioner fled from the scene. Stop. Thereafter, the case was registered as Women PS case number 0010/2025. Stop. The petitioner was arrested on 29/8/2025 and booked under section 78/79/351/356 clause 2/331 clause 4 BNS read with section 66 clause C and 67 of the IT Act 2000. Stop. The petitioner was released on bail on 3/9/2025. Stop. Thereafter, the petitioner and the respondent number 2 entered into a compromise by executing the compromise deed dated 12 September 2025. Stop. Among other conditions, the compromise deed stated that the parties declare and confirm that there was no force or coercion, and they had entered into the compromise with full consent and voluntarily, and into the compromise voluntarily and with full consent. Stop. It was also agreed that and then you just quote this para 2 to 8 from this page 20, okay, the compromise deed, page 20. Stop. Para. In view of the compromise deed, the petitioner therefore prays that the FIR dated 23/2/2025 and the connected criminal proceedings.
My lord, 23/08/2025.
Okay, 23/8/2025, and the connected criminal proceedings in respect of GR case number 94/2025 in connection with women PS case number 0010/2025 may be quashed and set aside. Stop. Para. Learned counsel for respondent number 1 and 2 have no objections to the set prayer of the petitioner in view of the compromise. Stop. And the respondent number 2 has also filed an affidavit to the effect that the compromise deed dated 12/9/2025 is confirmed, and she has no objection if the criminal case in GR 94/2025 is quashed and set aside. Para. Upon going through the compromise deed, it is seen that no useful purpose would be achieved by continuing with the criminal proceedings in the present case, as the proceedings are not likely to result in a conviction due to the fact that the compromise has already been entered into between the victim and the accused. So, accordingly, the FIR dated 23/8/2025 and the GR case number 94/2025 in connection with women PS case number 0010/2025 is quashed and set aside. Stop. It is made clear that the parties shall abide by the compromise deed, specifically with respect to paragraphs 2 to 8 of the compromise deed dated 12th September 2025. Stop. Application stands dismissed.
Obliged, my lord.
For orders, item number 12.
May I please, my ladyship, this is an application praying for impleadment of the Chief Secretary to the Government of Nagaland as contemnant number, respondent number 4.
Okay, will allow.
No, Your Lordship, before allowing the IA, Your Lordship, I have short submissions to make, Your Lordship. The order that was passed in WPC 250 of 2022, Your Lordship, here it is something to do with regularizations of the petitioners in terms within Office Memorandum 17/3/2015, Your Lordship. Now, Your Lordship, the 17/3/2015, Your Lordship is well aware. There is a procedure there. And the procedure is as such that these procedures are not done in the office of the Chief Secretary, but it is done between the department and the government concerned, that is the Principal Secretary of the Commissioners and Secretary of the concerned department, Your Lordship. Yes. It is this.
Acha, now I remember.
Yes.
No, the thing is, the Secretary is not impleted.
Yes.
Chief Secretary is also not impleted.
Chief Secretary is impleted as respondent number 1.
Chief Secretary is
Oh, okay, but the Secretary concerned of the department
Yes.
is not impleted. So,
pass
because
necessary
of that,
directions, yes.
since the Deputy Commissioner is the one who was delaying the matter,
Yes.
the Director of the department cannot direct
yes, that
the
is
Deputy Commissioner.
Yes.
But it is only the government which can direct.
Lordship, Lordship, in this issue,
Yes.
my limited submission will be this, Your Lordship. The director of a department, the concerned director of a department cannot send the file as far as the regularization of any of its staff is concerned directly to the Chief Secretary for regularization.
No.
It has to be
It has to be routed
Through the commissioner.
Through the commissioner.
Commissioner
the-
secretary.
The secretary of the department.
Yes, yes,
That's
yes.
right.
So the office of the chief secretary has got nothing to do with the regularization process as far as the office memorandum is concerned.
But here,
So-
my ladyship, the issue is, since the DLVC, district level verification committee is not sitting, it is only that for a direction that you seek. Because director cannot direct to constitute the
So in that,
DLVC.
yes, your
Then
lordship.
it should be the secretary.
Yes, it should be the
Not-
secretary.
Not chief secretary.
Not the chief secretary, your lordship. So
The
a direction may be
secretary- The
issued.
secretary of the concerned department.
Correct, correct, my lord.
Yes, yes. Because chief secretary is actually only the head.
Administrative head of,
Administrative head.
yes, correct, my lord.
I agree with that also.
Yes.
Yes, yes, yes. I think it should be the concerned secretary. Which department? Higher education.
Yes.
Concerned secretary of the higher education department.
Though he is not implemented as a respondent in the writ petition, then my lord, if that can be allowed.
No, your lordship, this honorable court have got the inherent power, your
No,
lordship.
that you can do.
Yes,
that you
yes.
can do. If the court feels that that is necessary.
Yes,
To
correct.
adjudicate, then you can
Then my
always
lord,
have it.
yes, my ladyship, in that case, then I may be allowed to
You
implead
withdraw
the.
this and
Yeah,
then-
I may be allowed to withdraw this and then allow me to implead the secretary as the
Yes,
respondent number 4.
Yes.
Learned Counsel, Mr. N. Nongkamer is allowed to withdraw the application with liberty to file afresh.
I deeply obliged, ma'am.
For hearing, item number 13.
This is the short point.
Yes, ma'am.
Did you get the instruction?
Lordship, on the instruction received, the matters become infractions because I'm told that her service has not been extended.
Not extended?
Yes, yes. Because for the last 19 years, her service has been extended for a year. Now her service has expired and the department did not extend her service. So there's
Since when?
March this year.
Yes.
That means you were not in contact with the petitioner
I was not
for some time.
informed. Yes, yes. So I'll have to withdraw the case.
Yes, yes. So what to do? You will withdraw or should
Yes,
we
yes.
dispose of as infractors?
I'll withdraw the case and if necessary, I'll take fresh steps
Okay.
because there's a new course of action.
Then we will pass over.
It can be withdrawn.
It can be disposed on withdrawal.
Also, Mr. Moa Jamir submits that that he would like to withdraw the petition with liberty.
Yes.
Or it will be a fresh.
No,
case.
it will be a fresh course of,
case,
yes, yes.
Accordingly, the matter is disposed of on withdrawal.
Much
Deeply
obliged.
obliged.
It was good that you sought instruction. Otherwise, we would have been uselessly adjudicating and hearing.
In fact, we are sorry that on that day itself, we should have come with proper instruction, but both of us were in the dark on the day when we heard the
You
matter.
also, you could
Yeah,
have-
I was
you
also
could
in the
have-
dark, your
yes,
lordship.
Yes.
Obliged. me.
Baba.